Good morning, Your Honor. Attorney Connor Pearson, P87-850 on behalf of Mr. Matthew Hargis. Sir, can you say your name for the record?
Matthew Hargis.
All right, so your client pled guilty to, to the charge of operating while impaired on July the 10th. I referred him for a screening and assessment. Have you had the opportunity to review the report with him?
Yes, Your Honor. There's a couple things I wanted to shed some light on as it relates to the PSI report.
Okay.
So under the page 2, under the drinking style and treatment history, it says he's never been involved in substance abuse treatment. So that's actually not quite accurate. He's had a substance abuse evaluation with Serenity Therapy and Raj Mehta. So I just wanted to make sure that that's correct.
Okay, I'll modify the report in that aspect.
And also, as regards to the recommendation, he's actually already completed Mothers Against Drunk Driving Impact Panel and has actually donated $500 to the program. So I just wanted to make sure you're aware of that.
He donated $500?
Yes, in addition to attending the program.
Okay, well, that's awful kind of you.
And the rest, I just had the rest for allocution.
Okay.
So he's 38 years old. He's a very close relationship with his family. He's a mother, father, 2 sisters. He actually is from this community. He graduated from Southgate Anderson High School in 2004. He's married. He's the father of 1 son, a 1-year-old. He graduated Michigan State University with a bachelor's in science. He does have a criminal offense. He has an MIP and a no tolerance OWI from his time at MSU. But he has since overcame those challenges. He's a certified therapeutic recreational specialist, and he owns his own practice called Semeco Recreational Therapy. Did I say that right? Semeco. And it's actually pretty inspiring, Your Honor. He's really, you really can call him a modern day miracle worker. So he works with people who have had traumatic brain injuries and who have several impacts on their day-to-day lives, and people who have like cerebral palsy and different patients with very debilitating conditions. So one example that I thought was really moving to me, so he had a patient who could barely walk more than 100 yards without a wheelchair. And Mr. Hargis has worked with this person over the course of the year, and at the end of that year, this person was, what, 92 years old?
No, that was a different.
Okay, so this person, over the year of working with Mr. Hargis, went from not being able to walk 100 yards to walking the whole Mackinac Bridge on Labor Day.
Nice.
So this person, incredibly smart person, incredible asset to his community, and has just been a service to others. As far as the incident that brings us here today, it's definitely a low moment for Mr. Hargis, but I just want to point out a couple of things. He's been cooperative with law enforcement. No one was injured during the incident. He has taken responsibility and accountability for this incident. Like I mentioned earlier, he's already completed the Mothers Against Drunk Driving Impact Panel. He's donated $500 for that cause. He's completed a substance abuse evaluation, and as part of that evaluation, completed a substance abuse education prevention program. He continues to do 12-step meetings. He's had perfect bond compliance. As far as his conditions for this court. Also, with the impaired conviction, he will have driver's license restrictions, so it's already taken care of by statute. And so with that in mind, we just asked the court to adopt the recommendation with limiting testing requirements and driving restrictions so Mr. Hargis can continue to serve his community and his patients.
Okay, thank you. Sir, is there anything you'd like to say?
Yes, Your Honor. I'd like to apologize to the citizens of Flat Rock and Gibraltar for putting them at risk on May 17th. I'm well aware of the potential consequences of my actions, as some of the patients that I see are a result of an alcohol-related motor vehicle accident. I'm very sorry for my actions. I'll do anything that I can to make amends and make sure that this never happens again.
Okay, well, all right, good enough. Well, I'm impressed. I'm impressed that you're you're taking responsibility, and just overall what I'm reading here, I'm going to place you on probation. I'm going to make it for 10 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number, you do have to notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. In order that you submit to chemical testing, PBTs and ETGs. I'll go along with that monthly. I'm going to order the victim's impact, but all I need you to do is provide proof. I made a note, attended, provide proof. So you just have to provide us with proof that you've attended that. Go to AANA at least once a week until you're in outpatient treatment. Once you get into outpatient treatment, you don't have to attend AA or NA any longer. I'm going to order 3 days jail credit, 1 serve 2. I'll let you serve those on by way of community service. So 2 days community service in lieu of jail, and I'm going to give you until September 10th. So 16 hours community service by September 10th. $300 in fines, $250 in costs, $75 victim's rights fee, $50 justice assessment, $675. Probation fees are $200 for $875. You have cost of recovery of $150, bringing the total to $1,025, and then you have a screening fee of $60. Your total is $1,085. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, Your Honor.
All right, so we have $1,085, and you can go down the hall. Can you pay that today, counsel?
Yes, sir.
All right, anything else? Any questions, either one of you? Anything?
Nothing for me, Your Honor.
Anything?
No, Your Honor.
All right, again, I cannot tell you how sorry I am we got out here so late. The meeting just went longer than I thought. My apologies. Good luck. Thank you.
Your Honor.
Thank you very much. Noah Russell. Do we have Noah? Okay, you need time to pay?
Yes, please.
How much, do you have anything today?
No, sir.
When can you pay this?
Can I be given 2 weeks?
Yeah, do you want to set up a payment plan? What do you want to do?
Yes, that's what I was initially trying to do.
Okay, how much can you afford to pay? You just tell me when you can pay it. If you want, we'll set up a payment plan weekly or bi-weekly.
Can we set up a payment plan bi-weekly?
Sure. And you want to start in 2 weeks?
Yes.
How much can you pay?
Can we do 50?
Sure. You pay $50 bi-weekly, okay?
Thank you.
And I'm going to start this beginning. You did the right thing coming in, by the way. I wish everybody would do this. You pay $50 bi-weekly starting August the 8th. If you don't have the money, just call the court. We'll go on Zoom, or you can walk in here on or before the due date. I'll be more than happy to give you an extension.
I appreciate that. Is there a way I can just mail the payments?
Yeah, they'll explain everything down the hall to you, okay?
One more question, Alan.
Sure.
I was wondering, is there a way to maybe ask for the fines and the fees to be taken off?
Do you have insurance now?
No, I'm working on it.
Why didn't you show up here initially? That you had a extra fee. Why didn't you show up?
Initially, honestly, I was not given notification. And
Where do you work at?
I work with the airlines, but it's not a lot of hours.
I'll tell you what, I'll reduce the fines and costs. I will do that for you. Reduce to $185, okay?
Thank you, Your Honor.
All right, best of luck.
Thank you.
Good luck, thank you.
Do I have to go to the front?
Yes. Okay?
Thank you.
You're welcome, good luck. Mario Enrique Pereira, I hope I pronounced that correctly, Pereira.
Perfect.
25R 514187. All right. Yeah, I gotta check something here. John, you have to take this back to, who's doing this, Mercure? Is it Mercure?
Yep.
Yeah, you have to have a seat right there, sir.
Okay.
Thank you.
What's wrong?
He needs to tell me whether or not there was an accident, minor injuries, no injuries, minor damage, whatever it is. Michael Jacob Collins, 25R514159. Come on up to the podium. Your name?
Michael Jacob Collins.
All right. Okay, you're going to plead impeding, right?
Yes.
Who's Latasha Collins?
That's my mother.
Is she here?
No, I ended up telling her to stay home because I was just running here for football practice. So I just told her to stay home.
All right, so so we need you to, you gonna be able to pay these fines today?
I already paid.
Well, that's posted by her.
Yeah.
It's in her name. She gonna allow you to apply the bond?
Yeah.
She is?
Yeah.
Okay, so you're gonna have to talk to them down the hall to the charge impeding, responsible or not responsible.
Okay.
Do you plead responsible or not responsible?
I plead responsible.
Default judgment set aside, plea is accepted to impeding. 175 is your total. Go talk to them down the hall and they'll tell you how to go about that, okay?
Thank you.
Good luck to you. Good luck with your football, Ray. Ray and Craig, 25F244329. And could I have seated up here Guy Neely, Jacob Guy Neely? You have a seat up here. Your name, ma'am?
Ray and Craig.
You're charged with operating with the presence of drugs. You have the right to a lawyer. Would you like one?
Yes, I do.
Okay, we're gonna set you up with a lawyer. And you can go out in the hallway and my court officer will bring the file out as soon as he gets here, okay?
Okay.
And then either way, you're coming back in front of me. Good luck. Jacob, Eugene, Dwayne, Guy Neely, 25F244420A and B. Your name?
Jacob Eugene Dwayne Keenan.
We have to stop meeting this way. Huh? You were just in front of me yesterday, right?
Yes.
Yes?
Yes.
And then when were you in front of me on another case, right?
Yes.
You gotta stop coming in here, okay?
Yes.
I'll give you a lawyer, all right? Okay, you got another suspend or vote denied and disobey traffic control device, all right?
Yes.
All right, go out in the hall, he'll set you up with a lawyer, okay? And either way, you're coming back in front of me, people against Urso. Anthony Jordan Urso, 25R252558. And could I have Gillingham seated at the table, my right, your left? Your name, sir?
Anthony Jordan Urso.
You're charged with assault and battery. You're here for arraignment and pretrial. You have the right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand that?
Yes, Your
Would you
Honor.
like a lawyer?
Yes, please. Your Honor.
Okay? All right. You can go out in the hallway. He will take the files out. He will give them to a lawyer. Either way, you'll come back in front of me, okay?
Thank you, Your Honor.
You're welcome. People against Gillingham. Jordan Gregory Gillingham, 25F256840. Your name?
Jordan Gillingham.
Did you meet with your lawyer yet
Yeah. Yep.
today?
Yeah. Yep.
Okay, he's not in here, so I'm gonna have to have you have a seat at that table right there. As soon as he comes in, I'll call the case, all right?
I think these ones might be all Mr. King's.
I think these are all, yeah, that's Mr. Gates. Is Kelly Ferguson here? All right, Mario Pereira, sorry, 25R514187. You can come on up to the podium, state your name, sir. Name?
Mario Pricker.
All right, so I had to have him take this back. It says no injuries, minor damage. You're gonna plead impeding, right?
Yes.
Responsible or not responsible to that?
Responsible.
I'll accept the plea, dismiss the failure to stop a shared clear distance, 195. You can go right down the hall and take care of that. You're all set. Good luck.
Sure.
Thank you. Ms. Ferguson, did you speak to Mr. Gaith yet?
Yes.
Okay.
I didn't get a hold of him, Judge. It just kept ringing.
Attaboy. Can you, well, John's going out. I don't know if he's getting Mr. Gaith or not. Can you see, rustle up Mr. Yeah, and tell him. Thanks a lot. Thanks. Bye. Okay, as soon as the lawyer comes in, I'll call him, okay?
Yeah, no problem. Mr. Gates, over.
Okay. You don't have an Amanda Cummings out there, do you, Lisa?
No, not on Zoom.
Okay. Good morning. People against Jordan Gillingham.
All right, let's talk about that. This hearing with Judge Michael K. McNally opened with the sentencing of Matthew Hargis, and it's one of those moments where the defendant's background and conduct post-incident clearly shaped the outcome. Hargis, represented by attorney Connor Pearson, pled guilty to operating while impaired. His attorney clarified a few inaccuracies in the pre-sentence report, notably that Hargis had, in fact, completed a substance abuse evaluation and other proactive steps, tending the Mothers Against Drunk Driving Impact Panel, donating $500 to the program, and finishing a prevention course. Pearson painted a vivid picture of Hargis's life: a Michigan State grad, business owner, and therapeutic recreation specialist, working with patients facing life-altering conditions. The highlight was a story about a patient who went from barely walking 100 yards to crossing the McNally Bridge, compelling testament to his community value. When Hargis addressed the court, he apologized directly to the citizens of Flat Rock and acknowledged the seriousness of impaired driving, noting that some of his patients live with the consequences of similar incidents. Judge McNally seemed genuinely impressed by the accountability and positive community work, ultimately sentencing him to 10 months probation with strict conditions: no alcohol or drugs, chemical testing, AA/NA, attendance until outpatient treatment begins, and a short jail term served through community service. The financial penalties were clear and itemized, and the tone was constructive rather than punitive. From there, the docket moved into payment plan territory. Noah Russell stepped up, looking to start payments in 2 weeks. The judge worked with him, setting up a $50 bi-weekly schedule and even reducing fines and costs when it became clear Russell's work hours were limited and he hadn't received proper notice for an earlier date. The exchange was straightforward, with the judge encouraging open communication to avoid compliance issues. We also saw a quick resolution with Michael Jacob Collins, who came straight from football practice to plead responsible to an impeding charge. The fine was applied to a posted bond in his mother's name, something Judge McNally made sure was approved, Don Collins left with both his case and his afternoon sports intact. Scattered through the session were a few arraignments where defendants requested court-appointed counsel, showing McNally's consistent approach: explain rights clearly, ensure understanding, and move the case to the next stage without unnecessary complications. Overall, the courtroom atmosphere was steady and efficient, with the judge balancing firmness on legal obligations with flexibility when genuine effort or unusual circumstances were shown. The standout takeaway was how preparation and proactive steps like Hargis's rehabilitation work and early compliance scans significantly influence the tone and terms of sentencing. And as always in this courtroom, if you show up ready, communicate honestly, and take responsibility, you're more likely to leave with a workable plan than a surprise hammer drop. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.